All rise, please. Kennedy. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thanks, Ron.
Good morning, everyone. My name is Vicki Henry. My pronouns are she, her, and judge, and I'm your panel chief today. I'm delighted to be joined by Justices Shin and Brennan. We have 6 cases on for today. We'll take a mid-morning break after the 3rd case. We are very familiar with your materials, and I say that every time, and it's like you don't believe us. So, in fact, sometimes we know them better than you do. So we're a pretty hot bench, and I encourage you, your 15 minutes is yours to use as you want, but I encourage you to cut to the heart of the matter because that's usually where our focus is. For better or for worse, we do not allow rebuttal, and you can see all 3 of us have our iPads here. That's because we're, I can't say we're paperless, but we're pretty close, and all of your materials are on there. So if you see us looking at your our iPads, that's what we're looking at. With that, I'll call the first case, which is 2024 P161 Commonwealth versus Remy M. Jones.
Good morning, Your Honor, and may it please the Court, Andrew Power for Defendant Remy Jones. I'd like to begin with the first issue, the constitutional issue, that in 2021, when my client was charged, the firearms licensing regime was facially unconstitutional. Now, as a threshold issue, I'm sure the Court is aware that I applied for direct appellate review on this issue. That was denied, but I'm still asking the Court to report this issue to the SJC under Chapter 211A, Section 12, because I believe that it's an issue that needs final determination in the SJC. As far as the standing issue, which the Commonwealth has raised, my client has standing under Lodeholt and Johnson, those 211 SJC cases. Even without having applied for a license, the law is clear that the issue of its validity is presented even in the absence of an application for a license. That's Lodeholt quoting Gordon. I also submitted Justice Thomas's dissent on a denial of cert to the Court, which also makes clear that a defendant can always raise unconstitutionality as a defense where a statute is invalid upon its face and an attempt is made to enforce its penalties in violations of constitutional right. And Justice Thomas quotes from Smith v. Cahoon and also a number of First Amendment cases that also apply in this Second Amendment context.
So if we were to accept your argument that the statute is unconstitutional, what would be the impact beyond this case?
I can't really go beyond the impact on this case, I believe, would be dismissal of the indictment.
Of just the one charge?
Of the gun charge, yes.
Right, but not the assault and battery charge. There's no argument about the assault and battery charge, right? Okay.
Beyond this case, that's why I think it's up to the SJC. I believe if the statute is invalid, other defendants could raise challenges to the statute, and perhaps they already have. The last issue is also the preservation issue that I want to address before getting to the merits. Now, obviously, this was not raised in a motion to dismiss prior to trial, so the standard would be substantial risk of miscarriage of justice, but if a statute is unconstitutional, it's invalid, and conviction for violating an invalid statute is a miscarriage of justice, just as a conviction based on insufficient evidence, whether preserved or not, meets that substantial risk standard. It's basically a jurisdictional issue. You know, the courts have no jurisdiction to punish somebody under a law that is facially invalid. If there are no questions on that, I'll move to the merits of the claim. As I stated in my brief, there's a discretionary licensing regime that was in effect in 2021 when my client was charged. The front end of the discretionary regime was the licensing provisions of Chapter 140, Section 131, which provided that As this court said in Ruggiero, a first-line measure in the regulatory scheme, and it governs the issuances of licenses to carry firearms.
Can I ask you a question? Is it your position that Bruin holds that any licensing statute that employs may issue or other discretionary language is unconstitutional on its face?
Yes, the may issue jurisdictions, so there are 43 shall issue jurisdictions, 6 may issue jurisdictions, and the Supreme Court made it pretty clear, and I'll quote at page 21, 23 to 24, in may issue jurisdictions, authorities have discretion to deny licenses even when the applicant satisfies the statutory criteria, usually because the applicant has not demonstrated cause or suitability. So it's not only the cause or suitability factors, it's the may issue regime itself. It's the discretionary regime that violates the Second Amendment right to carry handguns for self-defense, subject only to certain reasonable and well-defined restrictions. So,
how do you reconcile that reading with footnote 1 of the opinion, which says that 3 states have may issue regimes that operate in practice as shall issue regimes?
well, I'd simply point out that Massachusetts may issue regime is very similar to New York's may issue regime.
But that doesn't go to the facial constitutionality of a may issue regime. And the holding of Bruin is that New York's proper reason requirement is unconstitutional. So if that, proper cause, that's analogous to Massachusetts' former good reason requirement. So under that reading of Bruin, would you agree that good reason is severable from the Massachusetts statute?
No, I don't believe so. I believe the may issue, the discretionary language, as Justice Kavanaugh stated in his concurrence, joined by Justice Roberts at page 2161. May issue regime is constitutionally problematic because it grants, first, open-ended discretion to licensing officials, and second, authorized licenses only for those applicants who can show some special need apart from self-defense. And again, 1, the unchanneled discretion for licensing officials, and 2, the special need requirement, in effect, deny the right to carry handguns for self-defense.
That's an opinion that's joined by a total of 3 judges, right? So in terms of footnote 1 in the main opinion, you can remind me, but how many judges were part of that? Wasn't that a majority?
6.
And they say, as Judge Shin points out, that 3 states at least have discretionary criteria that appear to operate like shall issue jurisdictions. So doesn't that mean that it's not necessarily inherently unconstitutional?
I believe that it is. Is Massachusetts included in that number? I don't believe so.
It is. They list Connecticut, Delaware, and Rhode Island, but of course we don't know.
I think that excludes Massachusetts then.
But doesn't that necessarily mean they're not per se unconstitutional if in practice they operate as shall issue regimes? Just the language may issue does not render the statute unconstitutional.
Well, we can't say beyond that footnote what the statutes actually say. Do they operate as shall issue regimes? Do they eliminate discretion to the licensing authority?
To prove facial unconstitutionality, you need to rely on something more, it seems, than just the language of Bruin. Bruin itself does not say that all may issue regimes are per se unconstitutional. So there has to be something more in the statute.
Bruin says that New York's may issue regime is unconstitutional.
It says that New York's proper cause requirement is unconstitutional.
But it also says that the may issue regimes are unconstitutional because they allow excessive discretion to licensing authorities.
So
I think that's pretty
what
clear
language in particular in Bruin are you relying on for that may issue piece of it?
At the piece that I quoted from 2123 to 2024, authorities have, in may issue jurisdictions, authorities have discretion to deny licenses even when the applicant satisfies the statutory criteria, usually because the applicant has demonstrated cause or suitability. So the fact that they're dividing jurisdictions into may issue and shall issue, criticizing may issue, upholding shall issue, and exempting those 3 may issue jurisdictions that operate as shall issue jurisdictions means that Massachusetts is a may issue jurisdiction that falls into the category of excessive discretion allowed to licensing authorities. And I think that's clear from the amendments that were made immediately after the Bruin decision. About 6 weeks after, the legislature struck all of the may issue language. They got the message. May issue is unconstitutional. And if you look at the language of the statute and the legislative purpose of the statute, as stated in case after case before Bruin, it is an intentionally discretionary system. And those authorities are authorized to basically use their discretion within reason to deny licenses for any reason they consider appropriate.
Not sure that it's terribly relevant, but just so we're clear, there's nothing in the record that indicates that your client ever applied for a license or the reasons that he might not have been eligible to apply, or is there something in there about that? That he would not have been eligible for a license in Massachusetts?
In the record or at trial? There is something.
In the record, yeah.
At trial or?
No, I mean, in the record that we have.
In the record, there is evidence that he had a prior conviction.
So that would have made him essentially, at least under the, even under the new version, it would have made him unable to secure a firearms license to carry. Or an LC, he couldn't get an LTC.
Yes, correct. But that was not part of the record. That was not part of the trial.
Understood.
Record.
Yep, understood. Can I ask, just, I mean, before we get there, and we can keep focusing on this, and I'm sure you're aware, but the SJC is hearing, I think the case is Commonwealth versus Smith today on the CJIS issue.
Correct.
So why would we go near touching that issue?
Well, the issue was raised, you know, again, submitted to the SJC. They didn't take direct appellate review.
Right. But the issue they're hearing today in Smith is the same issue that we're hearing, right? It's literally the same issue.
I would say very similar.
Okay.
One thing we're saying that I don't believe they raise as pointedly is the diligence of the search.
Okay.
I think the opinion will probably address the diligence of the search because it's going to be probably necessary to their holding. But we really focus on the diligence of the search under the rules, and that Ms. Conway did not conduct a diligent search under what would be ordinarily understood and under federal interpretations of what constitutes.
And what would you have, I understand your argument, you would have had her, though, just get more information, get the booking sheet or the police report or other documents that then she could run comparatively? Is that where you say that
Other
her
documents to authenticate.
diligence was lacking?
Exactly, to authenticate the information she was given, and also other documents including his address, his place of residence. I think that's important.
So I guess what I'm asking then, is it the quanta of evidence, or is it the, in other words, you're saying she should have gotten other things, or she should have verified the things that she received, or both?
Both.
Okay.
So one thing that did you finish that answer?
Yes.
Okay. Well, I mean, one thing that's, I don't think crystal clear from your diligence argument is, I think you focus on the search, but it's also a situation of garbage in, garbage out. So if they didn't enter it in correctly, the search isn't going to find the right information, right?
Correct, and that also goes to diligence.
So, because I know, I mean, she ran his name, which it does appear from the trial record, she ran accurately, and she ran his date of birth, and there's also testimony as to his date of birth. So those aren't necessarily wrong, but if somebody like is a Red Sox Nation fan who was keying in his name, they might have keyed in R-E-M-Y rather than R-E-M-I, says the judge whose first name is Vicky with an I-E, who's been here 9 years with incredibly intelligent colleagues who every week send me emails addressed to my name spelled incorrectly. So I take it you're saying that because there's some possibility of wrong information being keyed in, that you would need more. You would need, like, I searched R. Jones, or I just searched Jones, or I just searched this date of birth, or I searched all May dates of birth. That's what I'm trying to understand.
Correct. As some of the federal cases state in my reply brief, the diligence of the search relates to the trustworthiness and the reliability of the search. So that also encompasses garbage in, garbage out, verifying, authenticating the information you've been given so you know it's the correct spelling of the name. You know it's not an alias, perhaps, so that he may be licensed under a different name.
Would
I
that not go,
don't-
I'm sorry.
Why does she have to verify the information? I mean, isn't that just on the prosecutor that they have to make sure they give her the correct information?
Well, the person who's conducting the search and testifying about the search is the person who has the burden of diligence, basically. The person who is testifying that I did this search and I couldn't find a record. Somebody gave me a name and a date of birth, and I typed it in, and that's all I got. That's not diligent enough.
Why is that not a weight as opposed to an admissibility question?
Because the
Or if-
rules of evidence and the rules of criminal procedure emphasize diligence as a prerequisite to admissibility,
But without defining diligence?
without defining diligence, correct?
That's just the record, right? It doesn't go to whether her testimony is admissible.
Oh, it goes to her testimony, too, because,
Why?
first of all, she didn't testify that she conducted a diligent search.
But what's the requirement for her testimony? Where can I find the source of that requirement for her testimony? I understand as to the record.
It would be in Justice Lowy's concurrence in Guardado 1.
So you're not relying on a rule. It's
Well, just because I think it's a fairly new area.
the issue in Smith is not the question of diligence, right? It's whether the witness there was qualified to testify about the search. Would you
I
agree with
believe, and
that?
also the accuracy of the search.
The accuracy of the search, okay.
I see my time is up.
I did one more question. So are you contending that to have a diligent search, the Commonwealth has to prove the defendant as either a resident of Massachusetts or a resident of where they are, a resident out of state, and what the state licensing rules are, and that if that state has a licensing regime, that they're not licensed there?
At minimum, they have to establish that the person is a resident of Massachusetts or an out-of-state, the state of residence, because if it's possible that the person is an out-of-state resident, different licensing rules would apply. So they'd have to do more. They'd have to investigate more.
Thank you very much. We'll hear
Thank
from
you,
the
Your Honors.
Commonwealth.
Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth. Your Honors, I'll start where we just left off with the diligence of the search. I think what was happening here was a little bit of a confusion between the question of the diligence of the search, meaning whether it qualifies for that hearsay exception, and the sufficiency of the evidence. So the diligency of the search is demonstrated from looking at the document itself that it returned, which you can see at Defense Appendix 42. You can see the name that was entered with the correct spelling.
Right,
and
the problem, though, is in the front end. How does Vicky, who could be spelled V-I-C-K-I-E, V-I-C-K-Y, E-E-E-Y, I'm amazed at the permutations and variations that people can come up with. And so I have to say, this terrifies me because, pretty much half of the population at least does not spell my name correctly. So you could have that certificate that says V-I-C-K-I-E, but that doesn't tell me anything about the front end. Like, does this thing have the wild card searching like Lexis or Westlaw, or even like the Board of Bar Overseers has?
Well, Your Honor, that's beyond the scope of our record here, so I can't actually answer that question. But what I can tell you is that
Well, the bottom line is for you going forward, though, this is a problem for you, and we've been saying that, or at least I have been for quite a while, and I don't know that a message is getting through. But if you have garbage in, then these certificates don't mean anything. I mean, even if you we have this capability, because if you go to the Find Mass Money, which we spend lots of money advertising, you can it's got all kinds of, you put in a certain search terms, but it gives you way more than you asked for, so you can verify you're not one of the, it's not under V. Henry or whatever.
I understand your point, Your Honor. However, here at Defense Appendix 42, you can see the search term that was entered, both the name and the date of birth. That's a
Right,
two-factor
but if somebody
check.
if they spelled his name R-E-M-Y or R-E-M-M-Y, or or, because we got a lot of, or they put in that his birthday, well, I'm not going to say his birthday, but if they put in the wrong digit for the birthday, then that search is going to say he's not in there, and it could be wrong.
All right, Your Honor, but that's a question at trial. That's a question for cross-examination at trial. I don't think that is going to disqualify the document from being admitted. Here they used a two-factor check, so they have both the name and the birthday.
Right, but isn't that the problem then? Because if there's a mistake in either one of them, like, why aren't they just searching for just Jones and then giving a printout that says, here's every Jones that has a license and he's not here?
Well, Your Honor, maybe that's an option in other cases, but that's not the case that we're looking at here. What we're looking at here is a two-factor check. And the fact that there could be a typo somewhere, a human entry error, there could be a typo or human entry error on a third entry or a fourth entry or a fifth entry. That's all the weight, not the admissibility.
Doesn't there have to be a certification for it to be admissible?
Well,
Record.
Your Honor, the witness that conducted the check herself came in and testified and explained everything. So there's no...
So that, whether the witness is qualified to testify as to this, that's the issue being heard today, right, by the SJC?
That's my understanding of that's the
So-
principal issue in the Quentin Smith case.
I'll ask Judge Brennan's question. Why shouldn't we wait for that opinion to be issued?
Well, you absolutely could, Your Honor. We didn't seek a stay because I think this case is resolved based on the business records exception that this document also qualifies under. I mean, the four requirements there, that it was made in good faith in the regular course of business, both of those are established when there's a government entity that has a statutory obligation to complete this record. So that's 1 and 2. 3 and 4 are, was the document created before the beginning of the criminal proceeding, and is it the regular course of business to make this document at the time of the event or close thereafter? Here, there's a statute that requires all the entries to be made in the MERC's database within 40 days of the application being made. So here, the crime occurred on March 7, 2021, meaning 40 days later, there would have been an entry if he had made an application that day. The indictment happened about a month after that. So we've satisfied both 3 and 4 in the business records as well. So this document...
Don't you either need a certification, though, or a keeper / someone who has some knowledge akin to a keeper of the record?
Yes, Your Honor, and that's from our position, that's what Amy Conway was.
Your position that Ms. Conway is...
Her title at the organization was not keeper of records. It was, I believe, litigation counsel or something of that nature. It was litigation and compliance counsel, volume 2 at 138. That's her title. But her job description was to be aware of how this database works, and you can see that from her testimony where she explained the structure of the DCGIS organization, how the records are received, what subunit of DCGIS receives them, enters them into the database, who controls the database, and she then accessed the database and did the check.
So you're saying that you either need a certification, which you don't have here, or she has, so you're just saying this works because she qualifies?
Correct, Your Honor, correct. She qualifies as a keeper of the records, even though that's not technically her job title. That responsibility is within her role at DCGIS.
She's pretty much, well, I think it's not part of the record. She's about the only person in the state right now that goes around and testifies at every gun case?
There's more than just her, but it's very few people, Your Honor. I couldn't tell you the exact number at this point because it's changing up and down. But it's just a handful of people in the state that exist right now to fill that role.
So backing up on constitutionality, the defendant argues that he has standing, in his reply brief, he relies on Commonwealth versus Gordon for standing. I was wondering what your read of Gordon is.
Well, Your Honor, I'm going to pivot from that question very, very slightly and say that Harris can easily be read to say that he does have standing to raise a facial challenge. In the footnote in Harris, it expressly says if you didn't apply and were denied, you lack the ability to challenge as applied. So you can clearly read that from Harris. They didn't go so far as to take the next step and expressly say, but you can always raise a facial challenge. So you could read Harris that way.
And do you think you can read it that way if we know from the outset that he couldn't have gotten a license? You think it's good enough? If you're thinking, even if he didn't qualify for a license, that doesn't matter?
Well, Your Honor, I mean, he was convicted under the statute. And so, I mean, this is the appeals court, so you're bound by the SJC. If you're asking me how I think the law should work, he should be precluded from raising an as applied because he didn't seek one, but he could always challenge the validity of the statute under which he was convicted. But you have to follow the guidance of the SJC, so I think to get there, because Powell and Lodeholt are not really clear, to get there, I think you have to read that footnote in Harris 5 and say the inverse of what it actually expressly says means you can make a
Well, do you
facial
think he's
challenge.
citing Gordon inaccurately, or do you think he's accurate about it?
I honestly don't know, Your Honor.
Okay.
I honestly don't know. But if we accept his argument that he can raise a facial challenge at any time, then that argument still fails because there are a myriad of factual situations where the licensure scheme as it existed at the time was valid. What
Can
we
you
pointed,
tease that out? Give me a scenario.
sure, Your Honor. What we pointed to was the first three categories of prohibited persons. That is someone convicted of a felony either in Massachusetts, Category 1, in another jurisdiction, Category 2, or has been committed to a mental health institution. That's Category 3. Then there are 7 other additional categories, but those first 3 categories have been found repeatedly to be valid restrictions on someone's ability to possess a firearm.
So that saves the may issue language?
I'd say yes, Your Honor. Even if it doesn't save the may issue language, even if I lose there, we still prevail because that may issue language is severable or separable, whichever term you want to use for that.
Right, and he says you didn't explain how it was severable, so could you do that?
Sure, Your Honor. So if you look at the actual version of the statute that existed at the time, that's at Commonwealth Brief, page 17, in the bottom half of the footnote, I put in bold the 2 sort of phrases that could be considered a problem, that could be considered to bestow that discretionary authority, both may issue and then has good reason. So it's as simple as striking the word may and then stopping the statute right before has good reason, at that and right before has good reason. So
Well, you can't strike may. It's a critical part of the sentence.
well, I think it makes a sentence not that grammatically pleasing, but we often read statutes that are not that grammatically pleasing. But the way it would read, if you strike that, beginning with the comma above it,
There would be no verb.
which the licensing authority or the colonel issue if it appears that the applicant is not a
That
prohibited
doesn't
person.
make any sense.
Well, I disagree, Your Honor, and I would simply say it tells them that they have to issue it if they're not within one of those categories.
Do you read Bruin to be holding that may issue regimes are unconstitutional?
Well, I read Bruin to expressly be saying that the New York statute was unconstitutional because they used the language, and I think Your Honor had it correct that the verbiage that they used in the New York statute was proper cause. Massachusetts uses the term good cause. So,
Or good reason, right? It used to.
yes, Your Honor, excuse me, for good reason.
You think good reason is severable from the statute?
Yes, Your Honor, because I think if you go to that line that has a good reason in it and just start at the and strike that, you just again remove the discretionary authority again. So really, what is the discretionary authority? It's essentially an 11th category in this statute. The statute says prohibited persons are categories 1 through 10. So if you're in one of those categories, you don't get a license. And we've also got this discretionary authority that maybe we don't give you a license even if you're not. So you can strike that discretionary authority. It's basically an 11th category. And the rest of the statute is completely fine. And I'd point you to the evolution of the statute that the legislature made in response to the Bruin decision. All that they did was strike the word may. They added the word shall, because that's a language we always use in statutes, but I would say that that's not even necessary. If you just remove the word may, it causes the same effect. And then they ended the statute basically, as I'm saying, where they removed the good reason. They added a requirement of an interview. So basically what the legislature told you was they always intended for the prohibited persons in categories 1 to 10 to exist. They just wanted an 11th category of the discretionary authority to deny somebody the ability to get a firearm. When they were told they couldn't do that in Bruin, they removed that 11th discretionary category. And they added an interview requirement that didn't exist before. But I would say that the discretionary ability, assuming that the Massachusetts verbiage of may issue and good reason is the functional equivalent of the New York language, which was proper cause, meaning it is problematic, then it is separable or severable from the statute because it is just an 11th additional category. Turning to the last issue that the defendant raised briefly with my remaining time, the sufficiency of the evidence.
Just before you get to that, on the case the SJC is hearing, your learned opponent says that the Smith case does not raise the diligence of the search issue. Do you agree with that?
No, Your Honor. I think it's inherent in the case that's being raised there. Is this person the right person to testify? And as a result of that, are they capable of doing the diligent search?
What about defining what diligent means? You presume they're going to do that too, or do you think it doesn't need to be done? Or
I think they're going to do that as well, Your Honor. But I mean, I think it's satisfied here. I think the two factor is enough to qualify as diligent, that they used 2 criteria on which they conducted their search. I think that's sufficient for diligent.
So when you say they use them together, though, right? She's not saying I searched for a particular birthday and nobody had that birthday, right?
Correct,
She searched the name and the birthday.
correct, in conjunction with one another.
Right, but
Correct.
that's my concern, is that could be the opposite of diligent, actually.
Well, respectfully, Your Honor, I think that's weight, not admissibility. So that's a subject for cross-examination, not whether the document itself comes in.
The 2 factors makes it less diligent because you needed to have both the birthday and that spelling of the name, right?
Well, I mean, that's an argument, Your Honor. That's an argument. I think it's the only safe way to do it when that's the information
You
that
could
they
do
have.
one at a time. You could do the name, and then you could also do the birthday. You can do that, right?
Presumably, they could do that, yes, Your Honor. If they only had one or the other, they had both, and here they checked both, and there was no record. If you want,
Just to be, they checked them in conjunction, right?
that is my understanding, Your Honor. That is my understanding. But again, the record is not perfectly clear about how that aspect of the search function works. So in light of whatever the SJC does in the Quentin Smith case, we may see records in the future that are more clear about how the search function itself works.
So the defendant argues that Bruin overruled the First Circuit's decision in Gold. Do you agree with that?
I do not, Your Honor. I think Bruin is the Bruin holding itself is very narrow, specifically to the New York statute. Then they drop footnotes to let other jurisdictions know that, hey, we've looked at your discretionary authority in your statutes, and we think a bunch of you have problems. And because they didn't clearly articulate, other than the initial footnote in one, the 3 or 4 specific state statutes that they talked about, they just sort of mentioned in a subsequent footnote there were 6, I believe there were 6 states that had discretionary authority, and they suggested that was a problem as well without expressly saying whatever verbiage you've used is unconstitutional. So I think Bruin is a little bit more narrow, and we would all like it if it would have been a little bit more clear, but.
All right. On the sufficiency, the defendant argues that the video equally supports inferences that Mr. Hicks retrieved the firearm from his own waistband, pocket, or jacket, or that it fell on the ground before he brandished it, and that there was no indication that the defendant ever possessed the firearm. What do you say to that?
Well, Your Honor, I say that the defendant absolutely possessed if the gun and the sock were wrapped inside of the jacket, then he absolutely possessed all of them together. Then I would point you to.
Because he held the jacket?
Correct, Your Honor. Correct, Your Honor. So even if it was wrapped up in the jacket, he held the jacket which held the gun. So he possessed it. And then I would also point you to the testimony.
How do we know he knew about it if it was in the jacket?
Well, I would point you to the testimony about what happened after his friend took the gun, tried to hit someone with it, dropped it on the ground. The mother picked it up and attempted to run away from the scene. The defendant then pursued her. And you can see that in both the mother's testimony at volume 4, page 91, and in one of her son's testimony, volume 3 at 52 to 53, where he pursued her requesting return of the gun when she didn't return the gun and continued away from her.
He argues that you're overstating when you say return of the gun versus him saying, give me that. Is that a difference?
Well, he argues that, Your Honor, but I think if you read the actual testimony, you'll see that what he did was, according to the mother, that's when he grabbed me in an attempt to take the gun from me. And that's at volume 4, page 91.
That doesn't mean he's taking it back. It just means he's trying to get the gun, his friend's gun.
Well, I hear you, Your Honor, but inherent in the fact that he had the gun in his possession before the gun was then lost to him and his friend is trying to get the gun back. And then I'd also point you to the son's testimony, Jean, who said that describing the man chasing her down, he was trying to grab her because she had her back turned, so he was trying to reach for it. So he was trying to reacquire the gun.
All right, but the object was inside the sock the entire time until the police got it later, right? They got the sock and then the gun was in the sock.
Not perfectly clear when the firearm came out of the sock, but when the perpetrator of the fight, the participant in the fight, initially retrieved the weapon from the defendant, it was at that point in the sock. And when he initially sort of brandished it, it was definitely in the sock at that point.
So the video, though, is the only evidence that, and that can be sufficient, don't get me wrong, but it's the video that shows whether or not he had possession, correct?
Correct, Your Honor.
Okay, all right. I think we'll have to leave it there. Thank you very much. We understand your arguments, and the case is submitted. Well argued. Our second case today is 2023 P1416 Commonwealth versus Robert Earl. This case is partially impounded.
Good morning, Your Honors. Edward O'Brien appearing for Robert Earl. This was his initial commitment under Chapter 123A, Section 14, as a sexually dangerous person, which is significant because at the initial adjudication, he gets the benefit of a presumption that he is not a sexually dangerous person, which he does not get in any subsequent Section 9 petition trials. As a result of the jury's decision, he is committed for what is effectively an indeterminate life sentence. These cases are very difficult. The legal fiction is that we believe the jury can put aside their prejudices and fears of sex offenders and follow the court's instructions so that their verdict is not tainted by that prejudice, bias, and fear. The reality is that jurors are revulsed by the facts of the underlying offenses, as in this case. So there is a real threat here that a jury verdict may be tainted by their fears of sex offenders and their prejudices. Which brings me to the first issue, which is the prosecutor's improper closing argument to the jury. In this case, it is true that as an element, the Commonwealth has to prove prior sexual offenses. They have to prove also that there is a risk of reoffense. Here, the defense admitted there was no controversy. They admitted the prior sexual offenses. They admitted the diagnosis of pedophilic disorder. The battleground was on what Mr. Earl's risk of reoffending was. And so the issue for the jury was, what is the risk of reoffense? Not based upon what Mr. Earl did 40 years ago, 20 years ago, 10 years ago. It was, what is his present risk of reoffending? The prosecutor in his closing stood up, introduced himself, and the first words out of his mouth were to tell the jury that Mr. Earl committed despicable, horrible things to 3 innocent victims: his own natural-born child, his adoptive child, and another child who he had a familiar relationship with and violated that trust. He then re-emphasized that he emphasized the dishonor of Mr. Earl's dishonorable discharge from the Air Force.
May I ask a question? If you take out the words despicable and horrible, anything wrong with the argument? Because it seems, to me at least, that the facts of what he did were important in terms of informing the opinions of the QEs and then perhaps informing the jury's decision-making process on whether he posed a risk. Right, so if it just reads, if he stood up and said, he did things to 3 innocent victims, take out innocent. He did things to 3 victims and violated his own biological child and stepson. Because there's a difference, it seems, qualitatively, who the victim is, or victims are.
Well, I mean, as a hypothetical,
Right.
I mean, there's other parts of the argument that I think exceeded improper bounds of argument.
Yeah.
But in this case, by those use of the words, it's like, well, if the prosecutor didn't hit the jurors over the head with that sledgehammer, he'd be okay.
I guess my point is it really a great debate that the behavior was despicable on one level or horrible in some sense? And do you think that really the jurors were so inflamed by that, or they kind of could have figured out on their own that perhaps this behavior was...
Well, they're sitting there and they're
described.
supposed to be, their focus
Right.
is supposed to be on the risk of reoffense. And yet, right off the bat, initially, you get that sledgehammer of improper appeal to juror emotion. In other words, Mr. Earl is despicable. Mr. Earl
Well, so let me
is
ask you this.
horrible.
Is there not a difference between saying this despicable, horrible human being committed these acts versus this person committed despicable, horrible acts? I think there is a difference there, no?
I agree.
And isn't what was said that Mr. Earl committed despicable, horrible things? Should have been a better word, but so.
I agree here, Your Honor, with that is parsing very finely a difference. But in this context, the opportunity, the risk of prejudice, of inflammation, and there's the appeal to juror sympathy for the victim here. Innocent victims. No, the idea right off the bat was to portray Mr. Earl as a degenerate, despicable human being. That's improper. This was also exacerbated later on by the prosecutor analogizing the risk, the potential risk, if the jury released Mr. Earl, to that of a looming disaster, a tornado, a blizzard, some looming disaster.
What's the basis on which you're challenging that statement? So the jury were instructed that they could consider the seriousness of the charges. Are you saying that's not legally correct, or are you saying that the language that the prosecutor used was inflammatory?
I'm saying, I argued in my brief it was inflammatory, Your Honor, and it exaggerates that risk. I'd like to call the attention of Your Honors to the D'Amico's case. It was an unpublished opinion that was decided after I had submitted my brief. It was decided in July of 2024 at 104 Mass Appellate Court 112. 2024. This was a Section 9 SDP proceeding in which the court decided that the prosecutor's analogy of the risk to putting one's hand in a cookie jar and picking out cookies that were poisonous. So the prosecutor said, well, okay, under the static 99R, the defendant, the petitioner, has only a 4% chance of reoffending. But what if there's a 4% chance when I pull out that cookie it's poisonous? And the court said, oh no, that is error. That is a misstatement of the law. Now, that was not objected to, as here there was no objection to that. The court in D'Amico's found it did not amount to a substantial risk of miscarriage of justice.
But I'm not sure I heard an answer to Judge Shin's question. Was the jury to consider the seriousness of the threatened harm if your client were to reoffend?
The jury was to consider not the seriousness of the harm, but the likelihood, is the way the statute is written, Your Honor. Okay. Is whether a risk of reoffense is likely. And here, because there was no objection, there's no curative instruction.
There was an objection to that statement, right, about the tornado?
There was an objection, Your Honor, yes, to the analogy to the tornado. That objection was overruled, and again, no curative instructions, which really that later instruction, the general instruction to decide the case free of sympathy, emotion, to me pales as rather tepid compared to the jolt of the prosecutor's argument. What was needed was an immediate curative instruction to put the jury's focus back on track to what their job was, to assess the risk.
So you're up against the reality that there was no objection to the despicable, horrible things comment. So do you have a case that finds a substantial risk of a miscarriage of justice on similar facts?
Yeah, it is actually, Your Honor, a case that I cited in my brief. I believe it's Vasquez, where they found that the prosecutor invoked the Catholic Church sex scandal in a closing argument, which was not objected to. And the court found that that injected inflammatory, prejudicial taint and reversed. It's cited in my brief, Your Honor.
I see it. Thank you.
And that would be at 65, Massachusetts Appellate Court 305, 2005. The Commonwealth's case was far from overwhelming. The most objective, predictive evidence that was put before the jury was Mr. Earl's score on the static 99R, which is an actuarial tool used by psychologists. It's even Dr. Bell, the Commonwealth's qualified examiner, acknowledged that the static test was the gold standard for his practice in terms of predictability. It was based upon years of research and statistical analysis. It included factors such as the age of the offender, what they were convicted of, the relationships with the victim, the types of offenses, violent, nonviolent. Mr. Earl's score on that, according to Dr. Bell, was a 1. Dr. Nelligan gave him a 2, basically 4 to 5% chance of a risk of reoffending within the first 5 years, and a 6% chance over 10 years, which means that people, sex offenders, who with the same score on the static as my client, that was their predictive rate of recidivism, 4%, 6%.
Before we run out of time, can I ask you about the since his incarceration issue, the fantasizing about the victim's child? Because it strikes me, I'm not sure that your position is certainly a legitimate one, but it seems to me that the Commonwealth is just as much. Does since his incarceration mean since he got out, since he went in? Does it mean since he was incarcerated technically means sentenced, or was it during the time period, which we're not exactly sure as I looked at the record? Was he held in jail pending his trial? Is that when it starts? I just don't see that we could really, on this record,
Well, since
have a definitive sense that what was presented to the jury was inaccurate, that counsel's failure to address it was ineffective. And can you address that for me? I've asked you about 6 different questions.
Sure. Well, Mr. Earl, since his incarceration, had only one disciplinary report. Would you interpret that as saying, well, since he got out? No.
That's because disciplinary reports are inherently part of incarceration. I don't think sexual fantasies are necessarily.
Yeah, no, I mean, I'm going by the plain language, ordinarily understood by pretty much everybody. I think the Commonwealth has twisted that into a pretzel, with pretzel logic, and I understand the reluctance of an appellate court to reverse without going for a new trial, but I would say this is manifestly unreasonable when you have an issue that goes directly to the heart of the case, which was this, the Commonwealth expert basically say to the jury, disregard the static 99 because he's an outlier. There's no research. That's just his opinion. That's just their opinions. There's no research, no studies can they cite. They rely on this subjective opinion, which Dr. Bell said was worth as much as a coin toss. That is why the Commonwealth's case is not overwhelming. There's a response by the defense to every single aspect of that. They say he's not cooperative with authority. The defense says, look, he contacted the police. He notified them that he registered as a sex offender. He explained that he just went to the victim's home, not to see her, but to get his birth certificate. So he had no money, no job, no place to stay. He had the only disciplinary record he had was the faded ID, and that was it. He did not act up in prison. And as far as the instructions, I'll rest on the argument in my brief. Thank you.
Thank you very much.
Good morning. May it please the court, Stacey Gauthier for the Commonwealth. It is our position that this court should affirm the adjudication of the defendant as a sexually dangerous person. Starting with the issue regarding the prosecutor's closing argument, the first issue was unobjected to, the statement that the prosecutor had started the closing with about the defendant had committed despicable, horrible things.
Do you think that should have not been said?
He certainly could have made the argument without saying that, Your Honor. But he then went on to say, and His Honor has instructed you and will continue to instruct you that he has served his sentence. So he kind of, he says that.
That's like when someone says, make some joke and then said, just kidding, right? I mean, the bell's rung.
That's correct. Again, he could have made the argument, but it wasn't objected to, and the judge did later instruct the jury that closing arguments are not evidence. He also instructed the jury to not decide the case based on sympathy or emotion. So I would suggest that would have cured anything wrong with with saying that. Again, it was the first thing he said, and then he went on to focus on the rate of recidivism, which was appropriate, and it was certainly it was appropriate for him to argue the facts of the case. This is a sexually dangerous person case. The facts were bad, and he certainly is allowed in his closing argument to address that. One of the elements we had to prove was that he had been previously convicted of an enumerated sex offenses. So I would suggest that. There's no reason, to reverse the case. Here, certainly the judge, told the jurors that that closing arguments weren't evidence.
Maybe I'm a little hung up on this, but it seems to me that are we talking about word choice? So if he said brutal acts, that would be okay, but despicable acts are bad, or horribly violent, if they were violent, that's okay, but horrible things.
I did cite two cases in my brief, Degro and Howell, where in both of those cases, the prosecutor had said, like the horrible things in their closing argument. And those cases, there was no error found in the closing arguments in those cases. And certainly, this isn't a case where he's calling the defendant like horrible, an awful person. That's, I guess, what I'm trying to ask,
because that seems to me the distinction. If you,
yes.
Certainly it's improper to call the defendant a horrible person, a despicable person.
That's correct, Your Honor.
And a violent person, more generally, if his act supported, is improper. But it seems to me to say he committed despicable acts, he committed horrible acts. Again, others may disagree, but I'm not sure I see that that's so outrageous or inflammatory.
I would suggest it's rhetorical flourish. Certainly the jury would know how to take that.
Or accurately descriptive.
Yes, and I also, I contrasted it in my brief to the Commonwealth versus Fahey case, where it was like the whole theme of the prosecutor's closing argument was that the defendant was like a cowardly bully, who had victimized someone who was a more vulnerable person. And certainly the prosecutor here did none of that. He went on after that first statement to do a proper closing argument, I would suggest. But then there was the issue with the tornado. This was objected to, so this would be looked at as a prejudicial risk here. And I would suggest that this also didn't, inflame the jury's sensibilities or appeal to their sympathy. I mean, certainly, the whole case is about risk. One of the things that we had to prove is whether there's a risk of him reoffending, if not confined to a secure facility. So certainly the seriousness of the harm.
Why is the tornado analogy not similar to the cookie jar analogy?
Because here he's not asking to just consider the likelihood. He's asking the jury to consider the likelihood and the potential harm, both of which are appropriate. The judge had instructed the jury that they could consider the seriousness of the threatened harm. So here he's just saying, is it raining or is it the tornado?
Where does that come from?
I'm sorry?
Where does that come from, seriousness of threatened harm? Where did the judge get that from?
I'm sorry, I don't have the site.
It's not in the statute, right?
It's not in where, I'm sorry?
In the statute? Where can I find
So I have a
a
case.
source that says you consider the seriousness of the threatened
So
harm?
Commonwealth versus Boucher, Boucher, that's at 438 Mass 274, page 276.
I'm sorry, could you give the site again?
Sorry,
438 Mass,
274,
274. Okay.
page 276. And it's a 2002 case where it says the seriousness of the harm is a factor in determining the likelihood of reoffense.
Why is that? And just that statement in and of itself doesn't make sense.
That they consider how seriousness the risk of harm would be. Is it, like the prosecutor was saying, is it, do they think it's going to be a risk of rain, or is it going to be a risk of, something more serious like a tornado or a blizzard? So I would suggest that that was proper, and that did not, appeal to the jurors' sympathy. And with regard to the last issue, if there's no further questions on the closing argument.
So if we affirm, and are we blessing this tornado analogy? It seems like the Commonwealth's getting itself into trouble with these analogies.
Well, I would suggest that this analogy was proper. I believe that the cookie analogy, I believe that case was reversed because the prosecutor had made it seem like no risk was good. But here he's asking the jury to look at the risk. Is it a rainstorm or is it a tornado? He's not saying that there's like no risk.
Okay.
I think your opponent said that case was not reversed. Or are you saying it was reversed?
I'm sorry, maybe it was,
or
well,
not
it was
Vasquez,
improper.
the original.
I'm sorry, it was improper.
Okay, gotcha.
The argument about the poison cookies.
So on the, changing topics, on the issue about fantasizing about the 3 children versus that it was 1 child, he argues this is, that this wasn't cured and that this really went to his risk, and so we can't really dismiss it as not significant. What do you say to that?
I would say that regardless of who he was fantasizing about or not fantasizing about at jail, the defendant has 2 other big issues as far as recidivism. The first one being his lack of, sex offender treatment. All 3 of the qualified examiners had testified that his treatment was woefully inadequate. Dr. Bell had testified that the pedophilic disorder is a chronic lifelong condition, similar to alcoholism, and it doesn't go away without some kind of treatment. And here, all 3 agreed that he essentially had no treatment. He had nothing to help him deal with, his triggers when he got out. So I would suggest that was, regardless of who he was thinking of or not thinking of in jail, this was a big factor, I would suggest, for, in the jury's determination or in our proof that he had a high risk of recidivism. The other issue was that he had offended around the age of 60, where the examiners had stated that is an age where the rate of recidivism is close to 0. So I would suggest that was another, more important.
Can I say, I thought that it was after 60, and then his offenses were 56 to 60. So I just factually don't see the correlation there.
I think that it was around 60. They all thought that it was significant, and Dr. Bell called him an outlier. They had all.
I understand what they said, but I'm just asking whether the facts actually support that.
So he would have been.
Right, if the 0 risk comes after 60 and his offending ended at 60, just logically, I'm not sure I see that connection.
Well, I believe it was Dr. Nelligan who thought that it was significant that he had offended between the ages of 56 and 60.
Right. My question is, why, if it's post-60, that the recidivism likelihood diminishes significantly? It doesn't, do we have anything that says between 56 and 60 that that is of some significance? I guess my question.
Only what the qualified examiners testified to, that they found that it was significant.
Okay.
So you're conceding it was error to argue that he fantasized about children while in jail, right?
Well, I'm not...
You're conceding at least it's error insofar as he said children.
What the testimony, the specific testimony from Dr. Bell was that he told me that he last had a sexual thought of JP when he was incarcerated. So, I mean, that's not children, although there was evidence that Dr. Nelligan had written in her report that he continued to fantasize during times, you know, when he was offending actively and when he wasn't offending.
Right, but
so at least at
the
some...
argument was specifically about while he was in jail, which is more current.
So, yeah,
you would
the state...
agree there's no evidence that he fantasized about children, plural, while in jail?
Right, the statement was that he said that he last had a sexual thought of JP when he was incarcerated. That was a specific testimony.
Okay.
And then just with regard to the ineffective assistance of counsel claim, I would suggest here, again, there was no motion for a new trial filed, so the defendant's claim must appear indisputably on the record, and I would suggest the fact that my brother and I are both quibbling over what since means, that is an indication that it is not indisputably on the record. And so I would suggest that we would need a motion for a new trial on that. And if there's no further questions, all right.
Thank you very much. The case is submitted.
Thank you.
Our third case this morning is 2024 P753, Commonwealth versus Hussein Zaza. And we'll be hearing from Attorney Curran first.
Good morning. May it please the court, Dana Kernhan for Hussein Zaza. We challenge the court's actions in attempting to orchestrate a plea. Appellate courts in this Commonwealth have said repeatedly that judges shouldn't get involved in plea negotiations. And in this case, the judge not only got involved in it, he really attempted to orchestrate it. It was, he actually put forth a particular plea and said he should take a continuance without a finding, and that will keep him out of jail and maybe keep him from getting deported.
Can I ask you a couple questions about this? I'm going to start with your argument that appellate courts have said repeatedly that judges should not participate in plea negotiations, right?
Yes.
I mean, 92, Gordon dropped a footnote about that. And then, when was the last time any appellate court really addressed the difference between case management, I think is an integral part of the trial judge's role, and inappropriate involvement in plea negotiations? Because it seems like they're all older cases. All the cases are cited are 20, 30 years old, 25 years old.
Well, I think that's because the practice has changed.
In what way?
In what way? Well, 40 years ago when I started practicing,
It was all off the record and in the
we do lobby conferences all the time.
And I would say you don't see lobby conferences every single day on the record in open court.
Right.
That's the only difference.
Well,
Substance is probably about the same, right?
I think the substance is not necessarily the same. I think the difference here is it's not the parties approached the judge and said, what do you think of this? Would you accept this disposition? This was, the judge said, hey, you know, your guy ought to take a quaff. And
I'm not endorsing this judge's approach, so I'll get to that. But here's my question. So this case, in this instance, according to the record, there's one case on the list, so I'm not seeing it. But as you probably know, there are many courts where you have 20 cases scheduled for trial on a given day, 25 some places. 10 or 15 may be the average. Obviously, you can't try all 10 or 15 or 20 cases. So is it your position there's something wrong with the judge initiating some management of the case? Okay, what do you want to do? What are you looking for? What can we do in this case? Is that in and of itself inappropriate?
I don't have a big problem with that. I mean, I think, you know, if the judge says something like, is there any way of disposing this? Have you had discussions? That's fine. Where it goes beyond this is, you know, your client, I don't want to send your client to jail, he ought to take a quaff. Then brings up the complainant and says, this is what we want to do, and she says, well, he should be punished, he should do this, he should do that, and the judge says, guilty finding, this is a outrageous what happened. He said that a couple of times.
Right, but let me break this down into two pieces. The first is, we're reviewing this for a substantial risk of miscarriage,
Yes.
right? Okay, the second part is, one could read this as to say the judge was actually really trying to help your client who did not have a record and who was potentially facing immigration consequences. And do you think the judge shouldn't have been doing, I'm not endorsing what he did either, but you're saying he shouldn't have tried to help your client?
I think probably he shouldn't have. I think that if the immigration consequences, by the way, a quaff is not going to, is treated as a guilty finding, so that's not going to help him. I think sort of browbeating counsel into having his client take that plea, I think that's what happened here. And
On the issue of bias, though, it just seems to me, and you can obviously state your position if it's different, that he was trying to sell the plea to the victim as much as he was trying to push the defendant into accepting the disposition that he was looking to impose, or the result, if not the disposition, the result, which is not having a jury trial that day.
I think that's right, but
So how does that show he's biased? It seems, I mean, he's biased toward himself not having to impanel a jury, but how about toward either of the parties?
I mean, here's the problem. I can't, there are a couple of things that happen at trial that I think maybe are consistent with bias. For example, allowing the issue number 2 is appeals to sympathy, allowing all that to come in, allowing 2 witnesses to say she was very upset and things like that, even over objection. And then the taking over the questioning on recross-examination. On cross-examination, defense counsel brought out that, well, you know, you didn't take the clothing for DNA. And then there was a little bit of redirect, and then he started asking another question. You know, you didn't take the clothing, and the judge interrupted and said, well, you weren't trained in DNA preservation or DNA testing at the time, and brought that out and essentially killed a significant portion of the defense.
Well, before the judge did anything, the witness said, I am now, trained.
Okay, I think the proper response to that is to allow the parties to address that issue, if they think that's important. For the judge to jump in and start questioning the witness and essentially bring out, really undermine the defense on that, that's problematic. Now, I can't say that these things, plus the sentencing, where the judge accepted the Commonwealth's recommendation, I can't say that they are clear evidence of bias, but I can't say that they aren't. And that's really the problem. If there had just been a discussion, you know, I'm having trouble convincing my client to take disposition, or, you know, maybe we should discuss it before we go to trial, that would be fine. But
And nothing wrong with at least giving the defendant some sense as to what the judge perceives the value of the case to be as far as sentencing, based at least on the information that's available at the time.
probably not.
I mean, it seems to me that almost enhances the voluntariness if he decides to take a plea.
Yeah, and you know, I think, and the case law, by the way, is, there is some case law on it. There is, that is a little bit all over the map. I mean, Gordon was a Commonwealth's appeal where they reversed it. But that wasn't even the judge. That was the judge sort of acquiescing to the defense request to enter a plea. Hogan, that was a juvenile transfer, and that didn't involve a trial. Johnson, the ultimate sentence was actually, Johnson and Damiano were, the ultimate sentences were not severe. They were actually less than what the maximum was, or there was a discussion about, I won't take your plea unless, if I'm going to recommend more, if I'm going to go higher than what the Commonwealth recommends, I'm going to allow you to withdraw this plea. None of that happened here. It was really just the judge who jumped in and said, this is what I want to do. And so I cannot say that there was no bias here. I cannot say that there was bias, but I think that...
Nothing to suggest that the victim didn't want to testify. Well, that seems to be presumed as well, right?
Yeah, and I think...
Back to the contrary, it appears.
I mean, I think there is some suggestion, there is some, when you read the whole trial, it's consistent with maybe the judge said, okay, I'm going to put my thumb on the scale. So that is our position, and we think it created a substantial risk of a miscarriage of justice. There's the second issue, over counsel's objection. The prosecutor elicited from the complainant's mother that the complainant was seriously upset when she talked to her right after the incident, and she also testified that it was just as upsetting to her as a mother to listen to her daughter. And the Officer Hedrick, who took the complainant's statement, talked about how upset she was. And I think the prosecutor talked about how difficult it was for her to come in and do these things. And there were some objections, and there were some of these things that were, after the initial objections were overruled, that were not objected to. But we think this, especially when combined with the first issue, entitles Mr. Zaza to a new trial.
So the Commonwealth argues in response that the victim's state of mind or behavior following a crime has been admissible, and the demeanor is admissible, particularly to refute a defense contention that this didn't happen. What do you say to that?
Well, I mean, I think the victim can say that she was upset. I don't think other people necessarily, I don't think that that's necessarily relevant. And the fact that she was upset, it's sort of a double-edged sword. It really does appeal to the juror's sympathy. Unless there are any further questions, I'll leave the remaining points of the brief.
Thank you very much. We'll hear from the Commonwealth.
Yes. Good morning, Your Honors. My name is Rob Kidd. I represent the Commonwealth in this case, and I am standing in for my colleague, Stacy Sanchez, who's out at this time. Turning to the first issue, Your Honors, I would respectfully suggest to start out by saying that everybody standing at that bench on that morning knew that this defendant was going to go to jail if he went to trial. Why do I say that? The defense counsel, in his conversation with the judge, said, Your Honor, I spoke to him last night. I spoke to him at length. We sat down for 2 hours, and I told him, you're going to go to jail if you lose this case. So it was not a surprise to this defendant that he was going to go to jail, and it was not a surprise to the judge. As Justice Brennan referenced, it was the value of the case, and then in district court parlance, that's what it was, and that's what it is. So there was no, because of that and other factors that are...
Can I ask you, what about tying a jail sentence to going to trial, as it appears the judge may have done? Says that's the way he's going to stay out of jail, because if he, and it's inaudible, but I would guess say he goes to trial, but if he something's with the jury and the jury convicts him all right, he's going to jail. as opposed to saying, on these facts, looks like this is a case where some jail is warranted. Don't you think there's a difference there?
No, well, I would say the law tells us that just because a judge offers a plea deal, which may be a more lenient deal before the defendant goes to trial, does not make that inappropriate.
No, but don't you have to couch it in something like, well, if he steps up and acknowledges responsibility, if he shows that he's amenable to rehabilitation, if he makes it, which are all legitimate sentencing reasons, makes it so that the victim does not have to be re-victimized to the extent you would by testifying. Those are all legitimate reasons, if articulated. They weren't here.
I think if you look at it as a whole, they were, because, Your Honor, remember the conversation, he's got the victim there apparently at sidebar, and that's exactly what he says. He says, I don't want to have, I'm trying to balance things here, I don't want to have you testify. These are outrageous allegations. He uses the word allegations, I believe. And in that sense, he's communicating to both parties that he's trying to have something happen where there's a plea that will avoid this defendant going to jail. I think the overall impetus here is that there's no threatening, there's no heavy-handedness. The law says you have to show that has some sort of extrajudicial influence on him. I think that's the phrase that comes up in the cases. There's no evidence that he had any bias against any of these parties, that he knew them personally, that he found this particular crime, he didn't say something like, I find these crimes abhorrent or something like that. He was talking about these particular facts in this particular case. He stuck to the facts of this case. And the Johnson case tells us there are some factors that we consider, and one of those factors, there are some factors that we consider in determining whether the judge was biased, I believe, and one of those factors is the sentencing. And that's his vindictiveness, I guess. In determining whether a sentence was vindictive, what we look at is the length of the sentence in relation to its maximum. And we have here at the end of the trial, this defendant is facing 2.5 years in the House of Correction. We have a prosecutor recommending 2 years with 1 year to serve, and we have the judge going along with that, not exceeding it. And the cases talk about the sentence that was imposed in relation to the maximum. So you have a 1 year sentence here. He's eligible for parole. Presumably in 6 months, he's eligible to get good time, as I understand it. So there's no evidence here of a vindictive judge or an angry judge or a judge who is twisting arms. And I would suggest...
What about when the judge says, I'm trying to get justice for you and your family before the trial starts?
He does say that. Yep. He does say that. And again, that is in the context of, as Your Honor alluded to, of quote-unquote selling the plea, trying to get the victim on board with this. But at the same time, on the other, he's doing one hand and on the other hand. And on the other hand, he's saying I don't want to send this fellow to jail. He's an immigrant. I don't want to have him deported. I want to give him a chance, or whatever his words were. So I particularly. Maybe I might get in trouble if I say this, but I don't think that, from what I've seen in practice, that was anything that was over the line at all. Maybe that's a commentary on the practice as it is, that whether it's right or wrong, that's what I've seen. So if the court has any questions, has no more questions, I can move on to the next issue. So the next issue was the glasses here. The next issue was on the commenting on the victim's credibility, commenting on the victim's state of mind, her demeanor, and so forth. And that was a couple of times the word upset was used, and she was Mom described her as being upset in this phone call, or very upset in this phone call. She described her daughter as being very upset when she disclosed to Mom in person about these allegations. As I understand the cases, particularly McCoy, and it's some other cases, that is perfectly admissible, and that is not hearsay and is not a violation of the fresh complaint rule to comment on the victim's state of mind. And it's consistent with the fresh complaint rule, because as I understand the first complaint rule, excuse me, I'm too old, but as I understand the first complaint rule, it's sort of there to sort of give some corroboration to a victim's complaint of sexual assault because of the traditional and archaic view that society has that a victim of sexual assault can't be believed if she doesn't run out and report it right away. So they've carved out that exception to hearsay, and that the victim being upset is part of that. A victim, I guess, you know.
So does that apply here where the victim is reporting right away?
Yes, I mean, it's all part of that. That's all part of the Commonwealth's case. She reported it right away. Look, she's acting like, quote unquote, the stereotypical victim that people want to see, and I'm not endorsing that at all. I'm just saying that fits in with the first complaint rule, and that she's acting as someone who was upset, who was just assaulted, and that's consistent with somebody who was just assaulted. And there was a claim in the opening argument that these are, quote unquote, I think outlandish allegations or something like that, and an inference that to be made that she should not be believed, that this was somehow all made up. So this was certainly relevant to rebut the defense's case of a fabrication.
Any evidentiary basis at all in which the mother's reaction is admissible?
No, and I think we concede that, understandably so, in our brief, and I think that was a brief de minimis comment that we talked about. And I think, you know, in common sense terms, you know, any person would expect a mother to be upset when those allegations are reported. So I think the jury would have thought that, and they wouldn't have taken anything by that. And yes, so I would just say that my colleague did a very good job, I think, on the brief, so maybe better than I would have done in the circumstances. But,
So on this part where the judge asks a couple of questions, I mean, the witness testifies, I am now, yeah. Of course, we don't know if he said I am now, yeah, I am now, yeah, we have no idea. And then the judge asks two clarifying questions, and your learned colleague says the judge should have left it alone. He shouldn't have interjected himself into the questioning. What do you say to that?
yes, I would point to the Jimenez case, which I'm not sure what page that appears on a brief, but I can find it. And that talked about some factors that they considered in that case to determine whether or not the judge was inappropriate in jumping in and asking questions. And they said in that case, and there's a line of cases that talks about the admissibility or the permissibility of a judge to ask questions. But in any case, they considered in Jimenez, one, that the testimony was technical in nature, two, that neither police witness was an actual witness to the crime, and three, that the judge had instructed the jury that his questions should not be considered for or against, the defendant, his questioning. So I think all three of those things are here in this case, and we have a testimony, kind of a relatively minor point. And I think that even if the judge hadn't jumped in, I'm sure the prosecutor would have jumped in, or, to answer that question. The looming question in the jury's mind is he just said, not now. Obviously, the inference is that he may not have been at the time that he was conducting his investigation. So I think when you look at that Jimenez case, I think that it fits in that rubric, and yeah. So I don't have anything further unless the court has more questions.
Not to belabor the point, circling back real quick, Johnson was the case you cite, and that was over 25 years ago. Not a lot of recent authority that speaks to the parameters of what the judge's involvement in the plea ought to be, right?
Correct.
And from what you're describing, which I'm not surprised that say what the judge here, at least you did here, was not so beyond what you see in other places that it was shocking to you. Only question, I don't know. So is it your position, or is it your take that some guidance would be helpful in this, or maybe this just isn't the case for it, given the peripheral nature of it, given the, in terms of the main issues?
Yes, I don't see the need for it here. I think the court respectfully needs a little bit of a stronger facts. Unfortunately, in the cases that I've seen, there are no cases, there's no case where I can find where a case gets actually flipped or reversed because of a judge getting involved, and maybe maybe I'm mistaken, but, so
I mean, if it was a plea, do you think that'd be a problem? I know we're getting hypotheticals. If it turned into a plea, do you think we would have had a problem here?
I don't think
He
so.
promises that he's not going to have to register. I'm not sure he has the authority. He can make a recommendation on indecent over. I'm not sure he has the authority to say, you don't need to register. He tries to make it an Alford plea, but doesn't name it an Alford plea, and it's not really an Alford plea, what we're talking as far as an admission. I mean, I can go on, but it just seems to me that
Yeah. Well,
there
I
are
can.
a whole litany of issues, to your point, that may not really be so relevant to the overall outcome of this case.
Yeah.
Because the claims of bias are somewhat nebulous in terms of conduct of the trial.
Yeah, in answer to that, I do recall reading a case, and I hope I'm correct about this, but I should have written it down, but, and it might have been in our brief. I recall a case in Superior Court that was discussed in our brief in which the judge, before trial, said, on the record, I just want to put this on the record, I've offered Mr. So-and-so 5 to 7 years, and then after the trial, he sentenced him to like 15 to 20.
Okay, yeah, no problem. I can see that, yeah. It's more that, yeah, I'll leave it at that. I get your position on that.
All right, thank you very much. We understand your positions. The case is submitted. We'll take our mid-morning break, which will be 15 to 20 minutes, and we'll hear the rest of the cases for the day. Thank you.
Hold on, rise, please. court is now in session. Please be seated.
Welcome back. Our rules are still the same, 15 minutes per side, no rebuttal, for better or for worse, and we have 3 cases on for the balance of the morning. We're actually going to what was the 5th case on our list, 2024 P383, Peter Alex and others versus Arcserve USA LLC and another.
Thank you, Your Honor. May it please the court, Timothy Cutler on behalf of the appellants Peter Alex, Seda Alex, Steve Catanzano, and Fast Archiver. I'm going to follow your comments this morning, get to the heart of the matter. I'll try at least. So I'm not going to go over the factual background unless there's something that jumped out at anybody that they felt was needed clarification.
The one thing I wanted you to cover from the factual background is, are you saying that the summary judgment record showed that the defendants did make some sales of the email archiving system and didn't pay on those?
Yes.
Okay.
Yes, Your Honor. Exactly that.
And where's the best place for us to see that in the summary judgment record?
That should be in the deposition of the 30B6 of Mr. Anderson. There are 2 Andersons. There was one that signed the LOI, and there was another one that was CFO type from Arcserve. And I quoted his deposition testimony in the my opposition. Yes, so that would be the best place for that.
Thank you.
For the sales were made. All right. The argument that we feel that the judge was in error was that there were material disputed facts as to fraud, breach of contract, Chapter 93A, conspiracy, negligent misrepresentation, as well as covenant good faith and fair dealing. Currently, the only party opposing the or appearing on the defendant's side is Marlin. I will start with the fraud, therefore, on that. We are not seeking or arguing to change the terms of the APA. In fact, we were basing part of our position on 5.05, which is says that the parties, specifically the defendants, were not to engage in fraud. Rather, the argument is fraud in the inducement.
So are you not arguing, so for example, you allege breach of contract, correct?
Say that
You
again?
allege a breach of contract.
Yes.
All right. But you do not disagree, I presume, that the earn-out payments were not guaranteed under the contract?
They were not what?
Guaranteed. They were contingent and speculative on what might happen in the
On a
future.
certain level, yes, that things could occur and they may not be paid. That's correct.
So how then legally do we arrive at a position that
Because
if the things didn't occur, it's not a breach?
Because you have to go back. Every business transaction has a certain risk to it. It doesn't matter what it is. And when you enter that business transaction, you evaluate the risk whether you're going to go forward. And in this case, instead of taking all the money up front, the plaintiffs agreed to taking it over this period of time based on the representation of existing facts. One, that the customers were demanding this.
I'm going to just stop you. Are you pressing on appeal that summary judgment should not have entered on breach of contract? Or are you really focusing on fraud and the inducement?
I'm starting on fraud because of Marlin. My argument is should not have been entered as to breach of contract and fraud. But for purposes of the argument before you, I started off with fraud.
Fraud, okay.
But to Justice Henry's question on breach, can you just
Yeah, so,
Can you identify legally what
so the legal things.
was breached?
So my clients negotiated the purchase, and it was upfront the $3.25 million. They came back and said, no, we'd rather structure the payment over time. Client said, no, no, no. And they kept coming back with, hey, we have a financial model. This shows that that the sales will occur and it will so happen at a certain, that you'll get it. 2, we did a customer survey, customer management, and our customers are demanding this. On top of this, our sales force is really excited about it, and they want to sell it. We have in place everything necessary to roll this out worldwide. And there's a couple other ones, and those were the most important ones. So based on that, we're financially strong. We're very financially strong. We're a growing company. We're expanding. All of those were lies, right down to the fact that they didn't even have direct customers.
Right, so the judge says that even if you're right about that, that sophisticated, and he's looking at Delaware, or she's looking at Delaware law, that sophisticated parties may not reasonably rely on information that they contractually agreed did not form a part of the basis for their decision to contract. Is that wrong?
It's misplaced. And 2 things, I'd really like to address this issue of sophisticated parties first. And that is, I think, and I don't mean disrespect to any judges, but I think it's a cheap label. First of all, fact you're sophisticated doesn't mean you can't be defrauded. But 2, what does sophisticated mean? I represent clients in all facets. And for example, one client was a money person, investor, $40 million for these big financial houses, and he took his money and then wanted to start up some corporations. He came to me, and he didn't understand the fundamentals of how a corporation was structured. Yet he's got $40 million in his bank account, and he's been investing people's monies for years. So so the next question needs to be, when you say sophisticated as to what? I'm in business. I'm sophisticated as to sales of shoes. Does that mean I'm sophisticated as to computers?
Well, is the judge wrong that they contractually agreed that, I mean, basically that the things you're claiming are fraud were not part of the decision of contract?
First of all, Marlin was not a party to the contract, was a third-party beneficiary. Sorry if I'm being overly dramatic with my hands. Was not a party to the APA, was not a third-party beneficiary. The trial court confirmed that fact, but yet applied that to it. But Section 505 was put in specifically to state that there was no fraud. And under Delaware law, if you're going to apply Delaware law, it says that the law has to be, the merger clause must constitute an all-inclusive, non-reliance, and waiver provision. That's not what you have.
On the fraud claim, I thought you were arguing Massachusetts law applies.
I am, and I thought that Her Honor
Right, well,
but in Massachusetts law, it doesn't even apply. You cannot put
under Massachusetts law, as cited by the judge, for instance, the SJC's decision in Masingal says it's unreasonable as a matter of law to rely on prior oral representations that are contradicted by the written contract. So how do you distinguish that?
Because they're not contradicted. We're not changing the terms of any term of this contract. We're saying we would not have entered this contract had we known that the risk was too high. If there wasn't a chance at all for sale, they had models that they...
Okay, hold on. So I take the crux of your fraud claim to be, well, there are 2.
Yep.
First, that they made misrepresentations that they were going to really sell this product and market this product. And then second, that there was a lot of customer demand for this, so it was essentially pre-sold, all right? So let's take the first one. So you're saying that before your client signed the contract, that the defendants were making representations they were going to sell this product. The contract itself says they're not obligated to market this product. So how is it reasonable when the contract says that to rely on the contradictory oral representations?
Because the second one is the most powerful one.
All right, but let's take the first one. Okay, so how is that reasonable? So you were saying, before my client signed the contract, they said, we're going to really sell this product. The contract says they have no obligation to sell, so how is it reasonable?
What I'm focusing on is that everything is in place to sell the product. And that's what I'm saying, that everything is in place. We've already lined up everything worldwide. We already have the sales force. The sales force wants to sell it. Our customers are demanding it.
But then when you have a contract that says, we have no obligation to sell it, we can terminate selling at any time. I mean, all these alarm bells should be going off.
Let's look at that language. It's not as definite as being argued there. First of all, we have section 104. 1.048, which is the qualifier.
I should be able to find it, but can you give me a record reference if you have it handy? I'll find it if you get a shuffle through there.
It's Exhibit 2, it's Exhibit 2B, Record Appendix 441.
Thank you.
Do you have it?
Yep, thanks.
And then what?
Got it.
It's 104. 8, and that was put in. But before we get into that, we have 104B7. That's really the crux of what the defendants are arguing. Payments are speculative and subject to factors outside the control of defendants. That's just a catch-all term. And yes, we agree that there are factors out there that could come in to knock it off. If you've done any kind of securities work, everyone says they're speculative, but it doesn't wipe out every securities fraud claim out there. No assurance the sellers will receive earnouts. Again, we're not arguing that we're promised it. We were represented that the lay of the land was so that there was an extremely high probability this would in fact happen, and we won't go pursue everybody else. And we gave that up based on those false representations. That the agreement governs the parties' contractual relationships. Sure, we agree with that. Buyer has the right to use the assets as it deems appropriate, including modifying the buyer's capitalization. In other words, which we've already seen, this is a highly leveraged company, Arcserve, and they want to be able to go out and borrow more money from banks and other financial institutions. The sale of the assets do not constitute a security in the company. We don't disagree with it. Plaintiffs shall have no right to be a security holder. Don't disagree with that.
Can I ask you, because we're running short on time, I just want to get an answer to one question. On the 93A, do you disagree, I expect you do, but the question is why, that well, let me just ask it. Do you disagree that the 93A is wholly derivative of the breach and the fraud and the misrepresentation? Do you disagree with that? And therefore, if we disagree with you and don't find a breach of contract, any fraud in the inducement or misrepresentation, there is no 93A? Or do you disagree with that as a legal principle?
I agree that it is, I eliminate the word wholly derivative. It is related to that, but it can still stand on its own. You may not find a fraud claim, but the 93A can still go forward. So
in this particular case, I'm asking, I know that is a general proposition, but in this particular case, if we find no breach of contract, no fraud, and no misrepresentation, what is the independent basis for the 93A?
It's the same factual background, but they may not rise to the level of fraud, but they could rise to the level of a 93A claim.
So you're almost out of time. I really want to give you the chance to answer my question,
Okay.
which
And
is
so it was the
the section of the
They can't do
contract
anything
you were
they can't
reading
do
from,
anything-
excuse me,
Oh,
the
sorry.
question from the contract, the provision of the contract you're reading from says, "The buyer shall have no obligation to operate its businesses in order to achieve or maximize the earn-out payments hereunder, or otherwise have any obligation to continue the sales of the purchased assets for any period of time following the closing." So given that, how was it reasonable for your client to rely on the alleged representations that they were going to sell this product, put in all of these efforts to sell the product?
One, that's not the main focus of it. Two, Section 8, you have to look at Section 8, which is the next one, and that says they will do nothing to interfere with the sales.
Right,
And you
that's
have-
different from saying that they're going to make all these efforts to sell the product, right?
Right.
Okay.
So we're not suing on the failure to make the efforts. So I think the court, and that's been the misleading thing. It is the misrepresentation as to what the existing facts were, as to the conditions at the time of entering it. We're not saying if, you know, that's not the claim. The claim was that they were not the company and there were not the circumstances existing at the time of doing it. We would not have entered it had we known that they were going broke, they were basically an insolvent entity, that they were not growing, that the customers were not interested, the sales force didn't even know about it, had no interest in it. So there was no chance that the modeling that we had received was false. We take those into considerations into our risk analysis. And if all of those things are false, we're not going to take that risk and enter into this agreement. And that's the fundamental. And that's what distinguishes it from everything else, is that we're not changing the terms. And we had the fraud claim put in there because they had made those promises, 505, saying that there was no fraud. It was a basis of entering this contract, and in fact, there was fraud. And it's certainly a factual issue for the trier of fact. I'd apologize for cutting you off. That was bad of me.
Thank you. Just a second. All right.
Good morning, Your Honors. May it please the Court. My name is Whitney Willits, and I am here with my co-counsel, Chris Herbert, on behalf of the appellee, Marlin Management Company, LLC. Your Honors, I think you immediately questioned my opposing counsel on what we believe is the heart of the issue, and it's the language of the asset purchase agreement. And the trial court judge below did find that there could be a question of fact about whether certain representations were made, but the problem is, no matter what was said about the sales force, about customer surveys, about how good the company was doing financially, those representations would matter if the contract didn't say what it does. But the problem is that Section 1.04B7 of the contract gives us not just the statement that the plaintiffs agreed that earnouts are speculative, but that they were in no way, shape, or form guaranteed. And whether they were sophisticated business people or not, when presented with the language in 1.04B7, where it says that neither Arcserve nor any of its affiliates guaranteed that any earnout payments would be made whatsoever, you can't go into the contract, sign that contract, and then complain later on that the earnouts weren't achieved.
Let's assume Massachusetts law applies to the fraud claim. To find that the reliance was unreasonable as a matter of law, the Massachusetts cases say that the representations had to have been at clear variance with the terms of the contract. So let's assume it's true that your client made representations that there's this huge customer demand for the products, basically pre-sold. How is that necessarily contradictory to a contract term that says we're not making any guarantees? Why wouldn't that have induced the plaintiffs to sign this contract believing that there was going to be this demand for the product? I don't see any real contradiction there.
So I think that it requires looking at all four sections of 1.04B7. specifically capital B subsection there is no assurance that the seller will receive any earn-out payment at all. I mean, that's a flat-out clear statement that we can't guarantee that you're going to receive any earn-out payment, whether there's customer demand for that product or not.
But let's say it was false that there was customer demand for this product, and your client made the statement intentionally to try to induce the plaintiffs to sign this contract, when in fact there was no demand. I don't see the contradiction with the contract term that says we're not making any assurances. Sure, there are no assurances, but the plaintiff could have entered this contract thinking, though, that there was this demand for the product.
Yeah, I understand your question, Your Honor, and I think that is what's addressed by the last clause of B7, which basically, it's in capital subsection D of B7, which is that the buyer has no obligation to operate its business in order to achieve or maximize the earn-out payments hereunder, or otherwise have any obligation to continue the sales of the purchased assets for any period of time following closing. It gave Arcserve the right from day one to say, we can roll this product out tomorrow and stop tomorrow. And it doesn't matter if there was customer demand for the product or not. I mean, that's just blatantly what's read in the contract language, and the trial court adopted that following. And again, under Massachusetts law, this all goes back to the 1986 case of Turner, and that's where they first recognized the idea of, hey, what happens if you've got a situation where someone promises that they're going to make good efforts to market a product? In Turner, what happened was the purchasers bought a thermometer business, and during the negotiations that led up to that asset purchase agreement that also had an earn-out structure, the buyers kept saying, look, we are going to aggressively market this product. We think there's a good market for this. It's going to sell well. We're going to aggressively market it. But then when the contract was reduced to writing, it specifically said that that buying company had no obligation to market that product for sale. And so when you've got kind of that contradictory language, we don't want to allow parties to contract out of fraud. However,
I have less of trouble with the marketing piece. Where I'm having more trouble is if your client, in fact, falsely misrepresented that there was customer demand, I don't see how that's contradicted by the terms of the contract.
So with that one, Your Honor, there's 2 points I would like to make. First, there's not any evidence in the record that that survey was false in any way, shape, or form. The facial language on that survey said that there was a survey done and it asked the Arcserve customers, rank your top 10 priorities in terms of what you're looking for to purchase in IT and, computer infrastructure space at that point in time. And overwhelmingly, the category of archiving came back as number 1. Now, archiving can be email archiving, which is specifically what the plaintiff's product was that they sold to Arcserve, but it also speaks to the broader market of archiving overall. There's simply nothing in the record that says that that consumer survey was actually in any way fabricated or false, and so we don't believe that there was any sort of a false misrepresentation there. But even if there had been, you still have to look at the contract as a whole, which it does not include any of the representations that the plaintiffs wanted to incorporate. And specifically, I believe there's 2 emails that we had cited in our brief where Mr. Catanzano, one of the plaintiffs that developed the product here, had emailed his partners and said, in the asset purchase agreement, we want to have the revenue targets, the marketing spend, the sales quotas in order to drive sales of this product. We want those terms incorporated in the asset purchase agreement, and without those, we should not move forward. None of those terms got integrated into the asset purchase agreement, and the plaintiff signed it anyway. So taken together, we believe that the language of 1.04B7 makes very, very clear to the buyers that they could be in a situation where the only consideration they get is the $90,000 upfront payment, and then there's no earn-out earned after that point in time. And something I want to turn to as well, Judge Henry, you asked about the sales and what could be in the record to dispute the fact that the defendants did in fact make sales of this product and calculate earnouts. Respectfully, we pointed this out in our brief as well. The deposition testimony of Arcserve's 30B6 witness, he never testified that they booked sales but then didn't pay any earnout on those. What he testified to in that deposition was actually that Arcserve calculated the potential earnout based on GAAP principles for revenue recognition in software, and that specifically is what's authorized in the asset purchase agreement. The Appendix A to that asset purchase agreement specifies the definition of gross margin and says that that's going to be booked in accordance with GAAP. And so that's what we had argued to the trial court, was there was no dispute of fact that Arcserve did properly follow those types of calculations, look to see if there were enough sales of this product to actually trigger the earnouts under the APA, and there simply wasn't any evidence of that. And specifically on behalf of Marlin, who is the company that we represent here today, something else I wanted to point out is that it's a little contradictory and a little bit, I guess, confusing as to what the plaintiffs are arguing as the breach of contract claim and how it relates to Marlin. Mr. Cutler had explained in his briefing as well as today that he believes that Marlin cannot rely on the existence of the asset purchase agreement because there's that no third-party beneficiary clause. But our position has been that it's not asking Marlin to enforce and receive a benefit under the terms of the contract. And that's what third-party beneficiary case law addresses. You've got someone who's not a party to the contract who comes in and says, I want to sue to enforce this contract and receive a benefit thereunder. That's not what we're arguing. Marlin's position is that they can point to the terms in the existence of the asset purchase agreement to say that the plaintiffs were unreasonable to rely on representations that were made that contradict the language in the contract. And additionally, in the plaintiff's reply brief before this court, they did somewhat bewilderingly say that they are actually claiming that Marlin breached the contract, which is something that they had not argued below. And so we would just ask that that argument be rejected because Marlin's not a party to it, which the plaintiffs have conceded.
On the fraud claim, do you think it's Delaware law or Massachusetts law?
Honestly, the result doesn't matter. Under both, it would find the same thing. We believe that in that scenario, it would actually be governed by Delaware law as well because of the choice of law provision in the contract. But both below and here, we've argued that if you apply Massachusetts law, you end up at the same result, which is it's just...
So under Delaware law, the cases that you cite have to deal with integration clauses.
Yes, Your Honor.
So this is a boilerplate provision, right, in the APA?
It can be deemed a boilerplate provision, yes.
How specific does the anti-reliance have to be in the contract under Delaware law for an integration clause to bar a claim for fraud?
Yes, for that, Your Honor, it just has to make clear that you are not relying on terms outside the corners of the contract. And that is specifically what our asset purchase agreement does say here. In section 7.05, it just says that this agreement, the disclosure schedules, and the documents to be delivered hereunder constitute the sole and entire agreement of the parties with respect to the subject matter contained herein, and supersede all prior and contemporaneous understandings and agreements, both written and oral, with respect to such subject matter. And I think in that one, it actually goes a little broader than what I've seen as what I guess would call boilerplate merger language, because it's not just superseding any prior agreements, but it also is their understandings.
It seems boilerplate to me. And the Delaware cases, the provisions are much more specific, the anti-reliance provisions.
I would disagree, Your Honor. I think that if, as long as you're making clear that you are not relying on language outside the contract, which is specifically what this one says, that is sufficient to be deemed a, merger clause and an anti-reliance clause.
So are there Delaware cases that deal with the reasonableness of reliance as a matter of law that do not depend on a merger clause?
Not that I'm aware of, Your Honor, and I don't believe that issue was briefed below, so it's not properly before this court on appeal as well. But, something else that I think is important to note is that this is another situation where we're trying to enforce the language of the contract, and we're not in a scenario, like Mr. Cutler is arguing, where Section 5.05 somehow revives a claim of fraud. Something that we pointed out to the trial court below, and again here, is that Section 5.05 is not a quote-unquote broad misrepresentation provision, which is how the trial court characterized plaintiff's argument on that section of the contract. What that is it's simply a release of the seller. A release of the buyer by the seller, and that is where the buyer, Arcserve here, was released from certain claims apart from any performance under the contract and any claims of fraud and misrepresentation. Arcserve nor Marlin, they didn't try to use that Section 5.05 as an affirmative defense in the case. They weren't trying to invoke that. And so the plaintiffs have tried to repeatedly kind of turn that provision on its head and say, It's not actually a release of Arcserve. What it is it's an affirmative obligation or some sort of binding commitment by Arcserve to not make a misrepresentation. But that's not what that language is for, and that's not what it says.
Do you need the integration clause to prevail on summary judgment
I don't think you do, because
under Delaware law?
I don't think you do, Your Honor.
So what case, Delaware case, arises in the context where it's not, there is no integration clause, something similar to the Massachusetts cases?
I don't think that that was looked at below, and unfortunately, I do not know of one to give you right now, Your Honor.
So as we're here right now, under Delaware law, you do need the integration clause to prevail.
I don't think that that's necessarily true, because even without that integration clause, we still have to look at 1.04B7, which is where there's all the...
So I'm struggling because all of the Delaware cases that have been cited have to do with integration clauses, merger clauses. So I haven't seen one yet cited to us that deals with just the situation where the representations are said to contradict the written terms of the contract. Are you aware of any such Delaware case?
I'm not, Your Honor. But again, I think that you can kind of look at this in two independent reasons to affirm. And the first would be because we do have the integration clause here. But even setting that aside, I think it's pretty well established in both Delaware and Massachusetts that it is unreasonable as a matter of law to rely on any extra contractual statements that are contradicted by the contract itself. And so that is specifically what that Turner line of cases started back in 1986, and it's been followed, I think, as recently as 2020 was the...
Is it undisputed that your client said there was customer demand for this email archive system?
That was said, Your Honor?
Yeah, that was represented to the plaintiffs.
I don't believe that is disputed. It was stated to them, and there were documents in the record that was a survey result that they presented to the plaintiffs that say, here's the results that we got back from the customer survey.
Was that not, is it disputed or undisputed as to whether or not that was true?
I don't believe there's a genuine dispute as to that fact.
So it was not true?
I don't believe it was. It was true, I'm sorry, Under the statement that there was customer demand for this is true. Everything that we've seen in the record says that they actually did do this survey. There was no proof that that was somehow fabricated or false.
Okay.
And I think it's also important to note that once the purchase was actually completed here, the defendant Arcserve, they hired Mr. Catanzano, one of the plaintiffs, to serve as kind of the product manager to roll this out in the team to make sure this was going to the global footprint that they had advertised. And Mr. Catanzano was paid, I believe, upwards of $240,000 to serve as the project manager, go to global sales presentations, educate the sales team on what this product was, tried to make sales happen, and unfortunately, it just never sold at the volume that everybody wanted it to.
What about the allegations that Arcserve was financially stable and profitable? Is that disputed, that those allegations were made?
Again, we don't believe that that was a genuine dispute for purposes of overcoming summary judgment. As we pointed out to the trial court below, to support their claim that Arcserve wasn't financially stable, the plaintiff simply cited 180 pages of audited financial statements that were for Arcserve's parent company and didn't develop enough of the record to explain that. Now, on appeal before this court, they did actually cite one page of a 2016 audited financial statement.
Yeah, I'm not talking about in the breach of contract context. I'm talking about in the fraud claim, right? There are allegations that the defendants, both of them, made misrepresentations about Arcserve's financial stability, and when, as a matter of fact, they were already failing, so they didn't even have a team in place once the contract was signed to promote this product.
With that, Your Honor, I think that goes within the case law that we cited in the brief, that statements about kind of how well the company's doing and that corporate puffery is the language that is used, and I can't recall the exact case that used that terminology off the top of my head right now, but things about kind of financial stability and future performance, those, undefined and not really nailed down types of promises are not actionable misrepresentation under either Delaware or Massachusetts law.
Well, what if they were misrepresenting the current financial state of Arcserve at the time?
I think you have to get into a certain level of specificity, saying, hey, we're financially stable, or hey, we're profitable, we're growing. Those are not necessarily the level of specificity that you can base a fraud claim on. And I believe that was actually addressed by the Turner case as well, because they talked about the stability of the management team and the financial performance of the company, things like that. But those, again, were not actionable fraud. Thank you for your time, Your Honors.
Thank you. We're going to briefly call case 2024 P728, Department of Children and Families, and another versus Mother and another.
Yeah.
Counsel for the child cannot come in today, so we're going to need to reschedule the argument. I'm just trying to get you on, I'm sorry. I don't understand what happened, but I also want to get you on your way because we are going to have you reschedule this one. So you'll hear from our clerk's office probably later today or tomorrow about dates.
Okay.
Okay,
Thank you,
thank you. And I'm sorry for whatever happened. That takes us then to what will be our last case today, 2024 P367, John Doe 5503 versus Sex Offender Registry Board. Good afternoon, counsel.
You know, I looked and it says, "Good morning, Your Honor."
Yes, it's very close.
By the time I'm done, it'll be good afternoon. May it please the court, my name is Frederick Bartman, and I represent appellant in this matter. And, Your Honors, there is no evidence on the record before you that my client is at any risk to reoffend. And the finding that he was at low risk to reoffend is an abuse of discretion. And the strongest indicators that are indisputable on the record that he is not at risk to reoffend is that he has not done so in almost 30 years. And under the board's own factors, the 10-year mark is a strong indicator weighing against the possibility of reoffending. There's also nothing in the record and no finding that there's anything in my client's constitution that he suffers a mental abnormality or is engaging in any kind of repetitive or compulsive behavior of a sexual nature. These are...
Are you making that argument even if the hearing examiner could consider the allegations involving the restraining orders and the underlying charges?
Sure. And that's at the heart of this appeal, Your Honor, is that faced with the complete lack of evidence on the strongest indicators, the hearing officer sought to make findings out of what I'll argue is whole cloth, one of which is this idea that for a 2-month period or 3-month period with a single victim, he engaged in some combination of domestic violence and violations of restraining orders. The finding is based entirely on police reports. And
what about the affidavit of the
Sure. The
plaintiff and the
affidavit,
restraining order was the same as the complainant in the criminal case?
and I understand, and that's one of the rebuttals cited by my brother and argued by the hearing officer that because there was consistency in her initial allegation and she wrote it in an affidavit in support of the restraining order, that somehow lent sufficient credibility and
Put aside
reliability.
consistency, isn't one of the factors that a judge may, or in this case, an examiner may consider in determining whether a statement, a hearsay statement is reliable, is if it's given under oath, as opposed to just a report in a police, report, a statement.
But even that, it becomes tautological, though, when that same affiant exercises a Fifth Amendment privilege when asked to repeat those allegations.
Do we know what the
on
nature of the
oath.
fifth was?
Excuse me?
Do we know what the nature of the privilege was? It wasn't, do we know what it was?
Well, only that it was asserted.
Right,
and-
so we don't know that it was necessarily that I made a false report to the police, which arguably be a fifth. It could be any number of things that have nothing to do with the accuracy of her original statement to the police and/or statements under oath in an affidavit. And I think we can infer probably from the restraining order, which is part of the record, that there was a hearing in which he was sworn and then gave testimony to a judge, right?
So it's unclear from the restraining order record whether there was a hearing or whether there was an agreement reached, and nobody testified.
Well, even in an ex parte hearing,
Well, you would submit the affidavit and receive
well,
the
you
10-day
swear
order.
in the plaintiff and take testimony. You don't just do it on the affidavit, right?
That's a fair point, Your Honor. But the strength of the inference to be drawn here when somebody raises a Fifth Amendment claim on the very core issues that we're talking about here in these hearsay documents is that the reason for exercising that claim is somehow related. But we're left to speculate about that, and it is the board's burden by clear and convincing evidence. I understand that the subsidiary facts need only be established by a preponderance of the evidence, but the overarching idea that these documents from this one alleged victim are going to get us to the point of finding that he's at low risk to reoffend.
So let's pause for a minute. The board says there are two different women who have had received restraining orders against him. Is that right?
That is accurate, Your Honor, but that was, the other one they have absolutely no information on, nothing other than the existence of that for a 5-day period.
Okay, and then on this one, you argue the events are not particularly plausible. Could you explain further why you think they were not plausible?
Sure, because, and it's a little bit awkward to do that because I don't mean to in any way minimize the significance of domestic violence or reporting these crimes and so on, but these are government intrusions into my client's life that are at stake, so I respond to you in that context, Your Honor. The allegation here is that the alleged victim is upset because my client is seeing another woman. She goes to my client's home and confronts him, and then, and I believe,
Plausible, right?
certainly. To quote the victim, it got physical, I believe was her words initially. And then ultimately, my client's brother grabs her and escorts her out of the house. It is not for at least a couple of weeks, I want to say 3 weeks later, that she begins to supplement these claims with
She reports that night something, right?
Correct. But interestingly, despite the mandatory arrest laws that accompany domestic violence, that goes back almost probably 30 years now, there is no arrest, there is no arrest warrant, but several weeks later, she wants to just put on the record that he also threatened my life. And
You're talking about the restraining order, right?
yes.
Not to be picky, but to be accurate, it was 9 days later.
Okay,
I mean, just that's different than several weeks, not that that makes a big difference.
Then I don't mean to misspeak in that
Nope,
regard.
I just want to make sure the record's clear.
In the back of my
Sorry to
mind, I had
interrupt.
2
Go
to
ahead.
3 weeks before she went to the police and said, I want to put on record he did these additional things. And so it is impossible to ignore the assertion of the Fifth Amendment claim on all of these allegations without finding some connection to them.
Well, the alleged victim in that restraining order situation, her declining to incriminate herself while just testifying in court doesn't mean the allegations were untrue, right? Sorry for the multiple negatives there.
Correct. There's no way to know that for certain. I go back to the SORB's burden on this and the importance of this issue in the context of the very strong evidence that my client is not at risk to reoffend at all. And when you look at the SORB factor that relates to violence against women, they talk about a pervasive pattern. And what we have here, at best, even giving every benefit of the doubt to the hearsay allegations, is a single victim over a very short period of time in a 30-year period. And that is going to somehow be sufficient, and it was clearly the most important thing to the hearing officer to make a finding that there continues to be some kind of risk for my client to reoffend.
Did any of the restraining orders go past the ex parte stage?
Yes, the one that we're discussing.
Okay.
And just to kind of complete the circle on it, on the alleged violations of the restraining orders.
On the alleged violations, I'm sorry.
On the alleged violations, though, where there was also a fifth, but there was at least reports from the police that they corroborated the report by looking at text messages that were sent, which would have been in violation, no?
Yes, but there's not a lot of information in those police reports about what's in those text messages in terms of phone numbers, content, what they're relying on to somehow make it, corroborate the victim's conclusion that they were from him.
All right. I do want to move us to
Sure.
some of the other arguments, mostly because the board argues that the petitioner waived them. So they argue that the petitioner waived the argument that the examiner misapplied factor 16, that was not raised before the Superior Court. So where in the record did Doe raise that argument?
I'll accept that it wasn't raised, but it's part of the constellation of acts of discretion that this hearing officer used that I argue abuse that discretion and arrive at an unsupported conclusion. And if I may, even on a substantial risk analysis, this public place argument
Her little sister was home for at least one of the, right, and I mean, little sisters or little siblings like to tell. So
Right.
why would it be an abuse of discretion to say that was a risk of being discovered?
Because in this particular instance, in this particular case, there's that time that they were all in the living room together, but when you look at public place, on the 2 or 3 occasions that, and it must be 3 occasions, that the sexual activity occurred, it was in a closed bedroom. Right,
but SORB relies on Doe 10216 to say it's not, public place is a bit of a misnomer, it's more that it was open to scrutiny and that this qualifies because the little sibling was there.
Sure, but that same factor talks about that there's been no effort on the part of the offender to conceal the activity. And I believe if that, I'm not sure about whether I'm citing the case that Your Honor just raised, but in either that case or another one right on point, it talked about that offender having multiple victims that were all in the same room. I believe it was a living room. Mm-hmm. And so there was no effort to conceal, and I don't think the court ever actually resolved the issue of whether or not under the SORB's factors this should be considered a public place that weighs on the calculus for this. And I realize I'm running out of time, and I wanted, if I could, make an important point about the hearing officer's decision. Not only did he try to find ways to bolster a finding of risk in context to the most important aspects that suggest that he's at no risk, the hearing officer just dismissed, well, or didn't apply sufficient weight to several aspects of the record here. One was the sex offender evaluation, which he found not to be helpful for at least two reasons. One was the use of the static 99, which is the gold standard for looking at risk, I believe it's Factor 35 specifically requires them to consider empirical.
Is the board correct, though, that the plaintiff didn't provide evidence as to the type of sex offender treatment that he completed?
So that was their own exhibit, the sex offender treatment, which does have a cognitive core to it. But the other thing about the sex offender evaluation, Your Honor, is he was like, well, that's 10 years old, so that's not helpful. That's exactly the point. It's 10 years old, and there's been no evidence over a 10-year period that he has committed any sex offenses. So we get right back to the strength of the record.
Okay. I have one more question for you, which is they argue that the petitioner waived his argument that the examiner gave inadequate mitigating weight for the past completion of sex offender treatment. Was it raised to the Superior Court?
Was it raised in Superior Court?
Was it waived?
I'm afraid, Your Honor, I don't have a direct answer to that question. I'm sorry.
Okay. Do you have any questions? No. Okay. Thank you very much.
Thank you very much, Your Honors.
We'll hear from the board.
If it pleases the court, David Shinai for the board. The board's position in this matter is that the board had to find there was a cognizable risk to reoffend, and that this individual's behaviors since his 2004 classification gave them grounds, the hearing examiner grounds, to believe that there's still he still presents a cognizable risk to reoffend. That's essentially the board's position in this matter. Unless there's specific questions regarding those findings, I'd be more than happy to rest on my brief. I think that these issues were covered. I think the Attorney Department did a great job with his brief and made me work on my brief, but I think I did cover the issues he raised adequately.
What about his primary point, which is, look, he hasn't committed a sex offense in 30 years, and like, at what point does it just become an abuse of discretion to keep this open? And I get it. He's got other problems, and he definitely needs to learn to, either learns to not hit women, or he needs to learn how to protect himself from a false allegation about hitting somebody.
You know, one thing that's been happening, I think we've discussed this a couple of times, the new studies are coming out that Hansen's done regarding sex offense-free time. And one of the things he stresses that sex-free time in a community does not apply evenly to every sex offender. And what he's saying is that what you look for is sex offenders who have adopted a pro-social lifestyle, have support networks in place. They're going to reach a desistance level much faster than someone who doesn't. In this case, this individual hasn't shown that he has developed a pro-social lifestyle or that his risk has diminished to the point where he's reached that desistance stage. So I think that sex offense or offense-free time is the coming research. Right now, it's more in the middle stages, but again, differences are being put for different individuals, different traits. Another thing that Dr. Hansen also pointed out is that the risks someone presented at the time they were release from incarceration also impacts their desistance level. Those that are a high risk will desist at a much slower rate than those that are low risk when they're released. So there's different factors on this sex offense-free time in the community. But I won't deny that that is an area that is finally coming to the research in front of us, and that's what we're going to be dealing with. Probably for the next couple of years, I think those are going to be important research tools that we're going to be discussing, probably as other useful information as the way things are going in the SORB, but I think that that's issues that are more down the road. Right now, looking at the studies that are out there, this individual doesn't appear to be at that 2.5% desistance rate for someone who hasn't committed a sex offense in 20 years because he's not living a pro-social lifestyle.
So the issues that you say are waived, such as factor 16, why wouldn't that all fall under the general umbrella of substantial evidence, especially where we're reviewing the Superior Court's decision de novo?
Well, you know,
I think I've asked you this question.
Yes.
I don't mean to give you a hard time, but it's not immediately evident to me why there's a huge consequence of not raising it in the Superior Court.
I can give you my opinion or the board's opinion, that they differ, because technically this panel can look at these facts as de novo. I think the waiver issue for me is more, unless the issue is one where it's clear there's a substantial miscarriage of justice, that the hearing examiner really misapplied it completely, I think that would overcome waiver. If it's arbitrary and capricious, abuse of discretion, I think that if it's an issue of did the hearing examiner properly weigh it and it was waived down below, I think that has to be given deference to the hearing examiner's decision. But I don't think waiver in itself completely obviates your ability to look at that issue. That's my opinion. I may not hear the same thing when my superiors review this, but...
You're arguing waiver by not raising it in the Superior Court,
Correct.
right? Not before the hearing examiner, but Doe raised substantial evidence, right, before the Superior Court. So isn't this just all substantial evidence?
Again, the position is that substantial evidence is a big umbrella.
Yeah.
And it's hard for the board, if you're arguing at the Superior Court substantial evidence, to say, well, was it factor 16, was it factor 12, was it factor 11, to respond to it. So you basically make a basic substantial evidence argument, which is all the evidence proves by a clear and convincing evidence the classification level. So it kind of hampers the board to be able to address specifically what issue, and it hampers the court to figure out what is the specific issue in the substantial evidence that that the complainant has a problem with. I guess.
Are you all set with that one? I do have a question on pages 23 and 24 of your brief, which I don't expect you to have up here, although you might surprise me with that. The issue, the relevant part is that the court's issuance of the abuse prevention order bolstered the hearing examiner's determination that quoting, the girlfriend's statement to the police was reliable. And then you go on to say that because a district court judge found by a preponderance of the evidence that the statement regarding the physical assault was reliable, it was reasonable for the hearing examiner to make the same determination. I'm not sure, and then you cite Doe 496501. I'm not sure that's an accurate statement of law, and could you talk to me about that? Because
it's more of a connecting the dots kind of argument that a hearing examiner just has to find that the underlying facts have been proven by a preponderance of the evidence. And then you take all of the evidence and decide whether it reaches clear and convincing evidence. And I think the argument I'm making is a district court judge has already found by a preponderance of the evidence that this event occurred and issued a temporary restraining order. The idea being that the hearing examiner can give some credence to that in considering whether or not it's been proven by a preponderance of the evidence that the event occurred as alleged. I'm not saying that that's ironclad, but I'm saying the hearing examiner can give credence to that.
And I'll read it, but I will confess I did not. But Doe 496501, which you cite, is not directly on point. I presume and you say that the hearing examiner may consider subsidiary facts that have been proved by a preponderance. That's within the same, that case presumably is within the same body of information, not a separate judicial proceeding. Is that?
I think I was citing Doe 3177 for that.
Well, that one says, I'm
No.
looking at 496501.
Well, I could cite Doe
but then-
3177, it's probably more on point.
All right. I'll go
You
check
know,
that one.
as many times as I edit through my briefs, there's always something I've left out, or say, in fact, every time I read a brief for the appeals court, I say, I see a typo, or I say, why did I say that? And here we are.
Thank you.
Thank
Thank
you.
you.
That's our last case that's submitted. I think we understand your positions. I want to thank our court staff today, particularly because we had a little extra work there with the case having to be rescheduled, and we are in recess.
All rise, please.
Yeah, you too. Thank you. It's very kind.
Court is now in recess.